everyone, it's Kerry Griffiths, the Divorce Financial Planner, back with you again today. And I'm joined by a guest today, Natalie Sutherland. So Natalie and I know each other from LinkedIn. We get on like a house on fire, kindred spirit. So I was really pleased when she agreed to come along to the YouTube channel. She's one of my favourite solicitors because she talks in a really down-to-earth way and she's really easy to understand and communicate with. So she's the head of the family department at A City Law Firm, and that's actually the name of the law firm, A City Law Firm. And we've been talking a little bit around how we can help clients understand the process of divorce a little bit more, just so that you've got that insight and that knowledge before you kind of take those steps. So I'm just going to hand over to Natalie. Do you want to just tell us a little bit about yourself, Natalie, a little bit about your background?
Hi. Well, we got on mainly because we're both Welsh. Yes. So that's how we kind of came across each other on LinkedIn. So I'm Welsh. I'm a family solicitor. Been doing this for many years now. Live in London and practice in all areas of family law, and I love it.
Brilliant. Thank you very much. And so I've given Natalie a specific topic to talk about. It's one that I often get asked as a financial planner, and I'm not the expert to answer that. So I thought we would get an expert along. And the question that I wanted to Natalie to really start with is just understanding what happens if you can agree with your former spouse what the finances look like, and what happens if you can't agree. So what do those two routes look like? So I'm just going to hand over to Natalie. She's just going to talk through those, and I might ask us some questions along the way. Over to you.
Perfect. Yes, so the goal obviously is to try and reach agreement. Divorce proceedings, financial proceedings can be very stressful. They'll take a long time, and you're dealing with your ex-husband or your ex-wife, and you want to try and reach agreement on these things because you want to move on as quickly as possible. So there are lots of different routes that you can go down. Mediation is one of them. So you can speak to a mediator and try and reach an agreement with that mediator. So the mediator is not, they won't give you legal advice, they won't tell you what's the right answer, they will just help you reach an agreement. But then if you're able to reach an agreement in mediation, then you will put that agreement into a memorandum of understanding, but then you will both need lawyers to look over that agreement to advise you as to whether or not that's a good settlement that you've reached. And then if they do think that's a good settlement, they can put it into a consent order. And I'll come back to that. Other ways of reaching agreement is through solicitor negotiation. So you can both instruct family solicitors who will talk to each other. You can do an exchange of Forms E. So the Form E is the court form where you put down all of your financial disclosure, and when you swap it with the other side, they get to see what the other person's financial disclosure looks like. Then you put together a schedule of assets and figure out what's all in the pot. And then the family lawyers, because they have the experience, will be able to know what the parameters are of what a settlement might look like, what a court might order, and then we'll help you put forward offers. So you'll make without prejudice offers to the other side. They'll take advice on that, they'll respond, and then hopefully you'll reach an agreement that way. So, and if that's the case, so on these two bases, either solicitor negotiation or mediation, the solicitor then will draw up a consent order. So the consent order will set out all of the agreements that you reached, and then it will set out the orders that the court has the jurisdiction to make. So it will say it is ordered by consent that, and then it will list all the things like the house is to be sold, the proceeds are to be divided 50-50, there's to be a maintenance order, all those types of things will be in the order section. And then once you have that consent order that you've both signed, you then have to send it into the court, and it is the court's job, the judge, who will review it, and they will look at that consent order alongside your Form D81, which is your statement of information for a consent order. That is, and the reason for that is because what you've done is you've reached an agreement without using the court process. So the court will not have seen your Form Z. Yeah. It will have no idea about your financial background. It will just have a piece of paper in front of it that says what you want to happen. But the judge and the court is not just a rubber stamp. They don't just say, oh, that's what you want, okay, we'll give it to you. They have a duty to make sure that what you've agreed is fair. And obviously that's very important if you've got one party that's got lawyers and the other party who hasn't and doesn't understand what they're signing. So So what will happen then is the judge will look at what the order says and then what your D81 says. So the D81 is set out to show what your finances are now, and then the consent order tells the court what your respective finances will be after implementation of that consent order. And if they think that that is fair, then there'll be a seal, so they'll stamp it and then send it out to the parties. Sometimes, and this does happen, they will not stamp it, and then we'll write to both parties and say, well, can you please explain why you come to this decision, because it's not quite clear to us, and can you please explain the net effect? So and then obviously you have to go back to the judge, explain it, and then they'll rubber stamp it or not. So so then you'll have your order, and that is what will be implemented, and it will come into effect after you've applied for and got your decree absolute. If you're not able to reach an agreement, you've tried mediation, you've tried solicitor negotiation, you can't get anywhere, then one of you will have to issue proceedings. And that is where you are getting the court involved. You can still settle at any point. You don't have to just, once you're in the court proceedings, have to go through it to the end. And in fact, the court wants you to settle, because you'll have your first appointment, your first hearing, which is just case management. So it will just look at the Forms E, it will decide what questions you both have to answer to supplement that information, and then it will set down a date for an FDR. So the FDR is the middle hearing, where the court will try and assist you to settle. So the judge on that occasion won't be involved at all, but they are allowed to look at your without prejudice offers, and you make those offers in advance of the FDR to try and settle. And if you can't, and you go to that hearing, then your positions are presented to the judge, and the judge, with their background, with their experience, looking at the evidence that's before them on that day, and seeing both offers, will give you an indication as to what they think the court would decide at a final hearing based on that information. And that's really helpful, because for the clients, they're just hearing from you, their lawyer, as to what the outcome should be. But obviously there are other parties hearing from their lawyer what the outcome should be. And if you haven't been able to settle at this point, then obviously somebody's saying something different. So so when you go to an FDR, the judge, with their masses of experience, will be able to give you an indication. And that will either be somewhere in the middle, or it will be more for one party or the other. And then the purpose of that then is to hopefully you go outside of the court, and then you try and negotiate. So you will try and up your offer, or you'll wait for the other side to up their offer, in the hope that you can shorten the gap, close the issues, and come to an agreement. And then if you are able to reach an agreement at the FDR, the judge has the power to make that order as a consent order, because of course it is an agreement between the two parties, so it will still be a consent order. If you can't agree, so the judge has said something and you said, I absolutely don't agree with that, I think I should get X, I'm willing to go to court for that, then you have the right to do that. Nobody can force you to settle at an FDR. So then the judge at that FDR then will give directions, and they'll set down a final hearing. So at that point you'll have to probably file a statement, section 25 statement, setting out the reasons for the arguments as to why you say the judge should order what you want to order based on those factors. And then you'll go to a final hearing. Both parties will give evidence, and then the judge will give an answer. So not just an indication at this point, it will actually make a decision. So then you'll have a financial order that has been ordered by the court. So it will say it is ordered that. So and then it will be stamped, and then that'll be the end of the matter. So yeah, that obviously all takes a long time.
Yes.
And with everything that's been happening with COVID as well now, if you were to issue an application now, it will probably take a lot longer than it would have done pre-COVID, simply because there's just a backlog with everything. So there is a lot of pressure, judicial pressure, encouragement for people to use alternative dispute resolution methods. So mediation, but arbitration as well. So that is a very good way of doing things. You will choose your judge in that respect, and they're called an arbitrator. And but you have to agree, both of you agree to use that process. And then what is the award that is made in the arbitration is your binding award. I mean, there are ways of appealing it, but people should be going into it thinking that this is the court process, and you can get it done a lot quicker. So so you can basically take yourself out of the court process, even if while you still can't agree, but go to arbitration. So yeah, there's lots of different ways of trying to settle your finances.
That was really useful, and I think there is a lot of misunderstanding about how you can move out of the court system or into it, depending on how things are developing. And it is good to hear that encouragement from the judicial system to actually say, okay, let's see how much more we can negotiate and actually get consented, rather than actually go all the way through this system. So that's awesome. So while we've still got you on the video, and while we've still got your expertise here, Natalie, I just wanted to ask you a couple more questions. We probably won't go through them all that we talked about, Natalie, just because I'm conscious that, you know, we don't want to make this video huge and overbearing. But one that I think would be really, really useful, just to clarify, is what is the starting point for deciding the split of financial assets within a marriage?
Well, I'm happy to say the starting point is a 50-50 split. So that has been our starting point for 20 years now, I believe. The case of White in 2000. So which is great. I mean, that's how it should have been always. How both parties to a marriage should have that starting point of 50-50. But whilst it is a starting point, it is not necessarily the end point, because family law is definitely an art, not a science. There is no algorithm, there is no procedure, but there's no kind of fixed way of fixing every single aspect of it. You have to look at each case on its own merits, on its own facts, and the ultimate thing that we're trying to achieve is fairness. So and what is fair for one family is not necessarily fair for another. So so all the factors are looked at, and then we decide what is the best outcome. Well, not we decide. We argue what is in our client's best interest, and a judge will decide if you can't agree. So so factors which will move things away from a 50-50 split, needs, definitely. Yeah. So if a party needs more than 50%, then they are going to have a good argument for that. And the example for that usually is if you sell a house and you are the wife and you are the mother, and you've got the care of the two children, the court's first priority is to make sure that those children are housed. So so if a wife who has given up her career, who is a stay-at-home mum, who doesn't have a mortgage capacity like the husband does, then they will likely walk away with more than 50% of the net assets, because they need that to buy a mortgage-free home or to put down a much bigger deposit. So, and obviously that's fair, because the husband will either take away a smaller chunk to put where he will be able to put down a deposit, and then use his mortgage capacity to get a mortgage because he has a job and a bigger income. Or there are things like a measure order, where they put their interest in the property as a charge on it, so they don't touch it until the oldest child has left home and they've gone to university. And at that point, the wife would then sell the property to pay back the husband. So they have their money, but it's sitting there in the property. So so that's a sort of creative way of being able to split the assets, where the wife needs the home, basically. So so needs is definitely one way of moving away from a 50-50 split. There are other factors that a party might use to say that they should get more as well. So like inherited assets or pre-acquired assets. So if you say, right, well, I brought in all of these shares in the company that I set up way before we got married, or I inherited X, Y, and Z before I even met you, and I've kept all of this separate, that should be ring-fenced, and the court shouldn't look at that and should only split 50-50 the marital acquest. So what do you have built up during the marriage? And again, that, you know, the court will start at that if that's a good argument, but it won't necessarily end there, because if you still have a needs argument that says, well, I can't house myself and 2 children on half of the marital request, leaving you with half of the marital request and all the pre-acquired assets, clearly that's not fair. You don't have children to house, for example. So the court will then look to use those assets. Not necessarily, you know, put it all in 100%, split it all 50-50, but will look to move what it needs to create a fair outcome for the other party. So it's definitely an art, not a science. It's creative ways. It's figuring out what needs to happen to make moving on as fair as possible for
That
both
makes
parties.
perfect sense. And it is bespoke, as you said. It's about each individual circumstance, because, as you said, one thing that works for one family really isn't fair for another.
No.
One thing that I think is really important is that just getting across that the courts won't let you be greedy or your former spouse be greedy. What they will insist on is actually that the needs are addressed, and that actually ends up in a fair outcome, as you said. So that was perfect. Thank you ever so much. We're going to stop there, but I would love to have you back as a guest in the future if you're up for that.
Of course.
Yeah. So I will drop Natalie's links in the description on this YouTube channel if you want to find out any more, if you've got any more questions you want to ask her.
Yep.
And her contact details there as well. And many thanks, Natalie. It's been a real pleasure having you along today.
Thank you for having me.
Appreciated.